I'm really happy today to have Andrew Bull of Bull Blockchain Law joining me to discuss the topic of EtherDelta and more broadly the regulation of decentralized systems. So it's my opinion that this recent settlement with EtherDelta is kind of an important moment actually for the blockchain and the decentralized movement in general. And so I'm, as not a legal expert, as someone with a tech background, I'm excited to get the opinion of Andrew on how he thinks this kind of stuff might play out, and how, as entrepreneurs and engineers, we can kind of protect ourselves and make sure we're doing everything we can to be in compliance with the laws as we're experimenting and building with this technology. So for those of you who don't know me already, my name is Ben DiFrancesco. You can find me on Twitter tweeting about crypto and other nerdy stuff at Ben DiFrancesco. I always love connecting with folks, other technologists, entrepreneurs, people who are doing interesting things in the space. So by all means, if you have any questions, if you'd like to ever just connect and compare notes, shoot me an email. You can find me on GitHub, and you can check out my website, buildblockchain.tech. So Build Blockchain is a little bit of an initiative that I started earlier this year just to kind of gather and create useful resources for technologists, developers, entrepreneurs more broadly in the blockchain space. So as we know, in 2017, things really exploded, and it just became very difficult to separate the signal from the noise in terms of everything that's going on in this blockchain world. So this initiative that I started is my attempt to kind of help solve that issue. I know I've completely fallen down the rabbit hole on this technology, and so I am constantly striving to learn as much as I can. And I figured as I was doing that, it would be helpful to share those resources with other folks and to learn from them as well. So if that sounds interesting to you, please check out buildblockchain.tech. So today, as I mentioned, I'm going to be joined in just a minute by Andrew Bull of Bull Blockchain Law. So Andrew is the founder and CEO of that firm, and it's Philadelphia's first and foremost blockchain and cryptocurrency law firm. So Andrew is well known in the blockchain and cryptocurrency space as an advocate for clear regulatory frameworks to ensure those entering and operating in this industry are well equipped. And really, that's something that we need. You know, as a developer, as a technologist, certainly have had to think about regulation in the past, but I've never worked with a technology quite like cryptocurrency, where you're dealing with something that is completely unknown, where even the regulators themselves are having to figure out how this is all going to work. And so because of that kind of uncertainty and the fact that we're all kind of figuring this out as we go along, folks like Andrew, I think, are really worth their weight in gold. And so I'm excited to have him up here. And without further ado, I'm going to go ahead and invite Andrew up onto the screen, assuming the technology wants to cooperate with us today. You never know. Let's see. Hey, Andrew, how you doing?
Doing well, Ben. How about yourself?
Good. Can you hear me all right?
I can. Am I coming through?
Yeah, you're coming through great. So I'm going to go ahead and stop sharing my screen if I can figure out how to do that. Let's see. Well, how about this? There we go. So, Andrew, as we dive into this, I thought maybe a good place to start would be in just breaking down what this case was all about, and even before that, maybe talking about what the SEC is, what their regulation is, and also maybe I can give a little introduction to EtherDelta after that, and why it's interesting and why it's different from a traditional crypto or other kind of exchange.
For sure, absolutely. Yeah, first and foremost, kind of being in the space for quite some time now, the general notion that at least the SEC has put forth through their administrative rulings or speaking in public forums, it's really kind of centered around the general notion of consumer protection. And so when we break down kind of the actual statutory language that are in the two statutes that give the SEC their administrative authority and then also regulatory authority, it's very much that they're thinking from the perspective of a potential investor, or maybe in this context, someone using the exchange, rather than the actual people who have created whatever the entity that's being evaluated. And so I think that's kind of just like a general thematic point that's something important to keep in mind, is that they're very much coming from the perspective of the person maybe sitting on the other side of the computer who's using or operating the actual system itself, rather than the software developers. And interestingly enough, and especially in this case, and we can also highlight a couple other cases that build precedent leading up to this, that it shows a kind of a prime example of where they're focusing in on the perspective of the individual user rather than the actual developer. So from that perspective, I mean, realistically, there's obviously been a couple different administrative rulings, most importantly, the DAO, kind of dating back more than a year and a half, 2 years now. And since then, there have been multiple administrative rulings, and some of them have built on each other and some of them haven't, and some of them are kind of one-offs. And so maybe that's another kind of sub point about the EtherDelta situation, is like, okay, how do we actually set precedent that we can rely on in terms of defining core statutory terms of how they were applied traditionally, but applying them now in the cryptocurrency and blockchain context?
So what I'm hearing you say is that the SEC, their role, at least the way that they perceive their role, their reason for being, is to protect everyday people, consumers, who would be the ones purchasing a cryptocurrency or a stock or whatever it might be.
Absolutely, yeah. And when you think about accreditation requirements that we have, at least in the US, that's very much indicative of that general notion, because the SEC, they allow for all different types of exemptions, and the filing process and actual compliance that's affiliated with just soliciting to accredit investors is quite easy. And there's not much red tape. It's really not difficult. But when you factor in people who aren't accredited investors and don't have those accreditation requirements, that's really where the SEC kind of starts to clamp down and really starts to use their enforcement action.
So let me ask you a question that's gonna show my ignorance on this topic, just how little that I know. Does the SEC, as a quote unquote regulator, do they actually define and create the regulations, or are they simply an enforcement body that takes the rules that are on the books written by somebody else, or are they doing both? What is their role?
Yeah, so they're an administrative agency, and administrative agencies in the US are kind of considered the fourth branch of government. And so we have legislators in Congress and the Senate and House who actually do end up drafting the language for statutes that are passed at the federal level. And so, which usually is brought to light through whatever executive is in office and on the president's side. And then they're using that language or defining those statutory terms to maybe expand some aspect of the administrative or regulatory kind of framework for the US. So in this context, the SEC is an administrative body that has regulatory enforcement capabilities. Not all administrative agencies have that. And in this context, they are kind of the ones that are protecting the financial industry that has to deal with trading in securities, and then in this context, the operations of exchanges and things like that.
So that's interesting. So when you say that they have enforcement capabilities, what exactly does that mean and look like? Does that mean that they can kind of unilaterally assign fines and punishments, or do they have to like bring a case to court against somebody who would be, guilty of violating some regulation? How does that work at a practical level? Yeah,
for sure. So kind of both of what you just said exists in that so we'll just take the EtherDelta context as an example.
Perfect.
Coburn was fined to the tune of $380,000, somewhere around there. And that was a fine that was actually enforced by the SEC. Now doesn't have to do with the judiciary, which is the court system. However, the opportunity to bring cases like that in the judiciary is available to mostly anyone who received some type of enforcement action by the SEC. And actually, just recently, earlier this week, we had a federal judge in the California district deny the SEC from bringing a securities violation against a blockchain-based company called Blockfest. So that's kind of an example where it's an amalgamation of between the SEC being able to bring regulatory action, actually fine individuals or businesses that are operating in the space, but at the same time, the judiciary serves as a somewhat check on the administrative functionality of the SEC.
So that makes a lot of sense. So it sounds in a lot of ways, it reflects the nature of the U.S. government, and that there's multiple entities and there's kind of checks and balances on power, and that's good in a certain sense that nobody has that complete complete authority. But it also kind of makes this space tricky as well, because as these things evolve, there's no central authority to just say, here's definitely how it's going to be. You kind of have to wait for this process between these different entities to play out, to really figure out what's going on. And I think that's where some of the challenge comes from.
For sure. And interestingly enough, I mean, this is indicative of blockchain technology in general, is that removing the third-party component of whether it's a financial transaction or a smart contract, it actually ends up kind of somewhat disrupting the way that our judiciary is set up, because that branch of government really relies on those third parties either for verification or maybe accountability, culpability, depending on how they're processing transactions in the financial context. And so at the end of the day, when you're removing that from the equation and it's relied on a decentralized protocol or some type of open source network, such as EtherDelta, then typically, I mean, that kind of just removes a traditional prong that was in the test to evaluate what was actually going on. And so it's definitely a pretty substantial disruption in that context.
Yeah, that makes sense. And I think that's actually a segue for me to maybe give a little bit of background on the part that I have expertise on, which is the technical aspect of EtherDelta and how it was implemented and why it's different from a traditional exchange. So it's not, so in the case of EtherDelta, what's interesting about this case is not just that it was an exchange that allowed the trading of cryptocurrencies. So there are lots of exchanges that do that. You have Binance and Bittrex and a million others out there. Coinbase, in a certain sense, is an exchange as well. And so there are plenty of things that do that. What's interesting about EtherDelta and what makes this case something to watch in particular is that it was a decentralized exchange. So what does that mean, a decentralized exchange? So in a traditional exchange format, you just have a server that is owned by the company that's running the exchange. And all the data is just stored in a database on that company server, and they're administering that server. They have, complete control over the data and that server. And of course, they also create the interface, the front end website that allows you to interact with their servers. And on their servers, they're basically matching buy and sell orders. So you have some whatever cryptocurrency, you want to sell it for another cryptocurrency, and you are willing to accept this price, and so a buyer can come along and take that offer, and likewise a buyer can come along and make a purchase offer, and that can be fulfilled by a seller. And so it's just matching an order book between buyers and sellers, and that's the traditional role of an exchange that's done traditionally in a database on the back end of some exchange's server. And all the big exchanges in the crypto world that you're used to hearing about and working with, that's exactly how they work. And then, of course, those exchanges have, in addition, a component where they have to actually be custodians of the crypto that people are trading IOUs in the database for, such that if you decide you want to take your Bitcoin off of Coinbase, they have it somewhere so that they can send it to you. But in the interim, while you're trading, buying, selling on Coinbase or any other centralized exchange, it's just an IOU in a database that's completely controlled by the owner of that system. So what's different about EtherDelta is that their quote unquote backend wasn't a server that they controlled. Instead, it was a set of smart contracts that were written by the creator of EtherDelta, this guy named Zachary Coburn. And a smart contract is a relatively new concept. I mean, it was discussed originally by someone named Nick Szabo way back in the 90s, but really the first implementation of a viable smart contract platform didn't exist in the world until 2015 with the introduction of Ethereum and the Ethereum blockchain. And so what is different about a smart contract from other compute platforms, compute paradigms that we've had before, is that it allows you, as the creator of the system, a developer or an entrepreneur, to create a system where you can set rules in the system. You can write code in the system that even you can't break, right? So traditionally, if you own a server, if you're creating a web-based application, you own that server and you own that data, and you can ultimately have it do whatever you want. And what smart contracts are fundamentally about, and why I think they're so interesting, is that it allows you to create systems that where even you, as the creator of the system, can't do certain things, don't have certain aspects of control over the system. And you can do that in a cryptographically verifiable way. The source can all be verified. Anyone can look at it and audit it and know exactly what the system is capable of doing, and what you, as the owner of the system, what privileges you've carved out for yourself or what privileges you haven't carved out for yourself. So that's the new thing here that's happening for the first time. And as you mentioned, Andrew, that is something that regulators haven't ever had to deal with before.
Yeah, for sure. And it's interesting because if you look back through the administrative rulings, and also just kind of a side caveat is that the SEC sometimes does get a bad rap in the blockchain space for sure, because they're kind of the regulatory body. And like you indicated, the underlying kind of decentralized component of blockchain in and of itself, or at least in the smart contracts context, is that you're removing the potential need for that aspect of it. But I will say that having personally interacted with them on numerous occasions on behalf of clients, and then also in general with other law firms, they definitely have an interesting perspective where they are trying to blend regulatory oversight, but also allowing the technology to advance. And so with that said, I thought it was pretty apropos that they used DAO as an example, as kind of their first, like setting the administrative ruling, because at the end of the day, it was ostensibly a decentralized autonomous organization. Now, we don't need to debate kind of like the legitimacy of the DAO exactly, right, but the underlying principle still exists. So in that context, interestingly enough, the SEC, when they implement these administrative rulings, leading all the way up to the most recent one with EtherDelta, they are kind of the perspective that they're doing an evaluation on a case-by-case basis. So while we can glean some type of precedent from it, the authoritative enforcement aspect of that precedent is typically non-existent, because at the end of the day, regulatory administrative enforcement actions aren't actually setting precedent that need to be relied on by future governmental agencies when they're evaluating some other type of entity. Like, so for example, when evaluating some statutory provision in the Securities Act, of course, there's precedent there. And then we have the judiciary having rulings and cases, and that's where the Howey test comes in, which actually comes from a Supreme Court case. But at the same time, just because the SEC decided that EtherDelta was not fully decentralized and thus operating a securities exchange, that doesn't necessarily mean that all decentralized exchanges are going to fit into that same category. And so that's kind of an important distinction to make, and especially for people operating this space, is that this isn't a blanket ruling. This isn't a Supreme Court ruling where now this precedent is automatically set and will apply to everybody. So
yeah, and I think that's the interesting thing, and I think so. I think that ambiguity is kind of the challenge, and in a certain sense, the opportunity moving forward, right? So, I think it is very clear so that the SEC had a pretty cut and dry case in the case of EtherDelta, and we can talk a little bit about why that is in EtherDelta's case. And I think that's why Coburn, the creator, settled with them and didn't really put up a fight, it seems. And at the end of the day, I think got a pretty mild penalty, all things considered. It was like a $75,000 fine, plus the disgorgement of about $300,000 that he had received when he sold EtherDelta. So EtherDelta is actually still operating. He sold it to an offshore interest. But he had to give that money over, the money that he received in that sale, about $300,000, plus an additional $75,000 fine, which, you know, nobody wants to pay a $75,000 fine if they don't have to, but that's better than being in jail or being banned from trading securities or a number of other things that could have, I suppose, happened. So I think it's clear that they had the case against him. So it's clear that Coburn went over a line, and maybe we can talk a little bit about why that is. But what's not clear, and this is where it's a little bit scary, is where the line actually is, right? So he went over it, but where is it? And if you want to make sure you don't go over it, how do you know how to do that? That's kind of the challenge that I think we have right now.
Absolutely, for sure. And again, early days, recent aspect of the industry definitely lends support to that general notion. And what's interesting about the Coburn situation is that this is actually one of the first times that I've seen the SEC acknowledge remedial efforts on behalf of the individual who they were bringing.
Interesting.
And there's a provision in the opinion that notes Coburn's compliance and cooperation. I think that was also another factor, and they kind of pushed that as saying, hey, if you cooperate with us, like we understand that this is very, very beginnings in terms of the industry development, and therefore that we're going to factor that into our overall analysis. And I do want to also maybe piggyback on highlighting the general notion that there was about 3.2 million transactions that occurred on EtherDelta for the time period that they were evaluating. And at the end of the day, I'm sure $300,000 is not that much for him now that he's sold it off to an offshore entity. But at the same time, it's consideration.
Yeah. Yeah, no, that's a great point. And it's interesting to hear you say that. So I also read the briefing that you described. And just as an aside, one thing I'll note, you kind of made this point earlier, the SEC, they understand this technology, and it's very clear from that. Like, they're not like unsophisticated bureaucrats, like, you know, that are trying to apply laws to something they have no clue about how it works. It was very clear from the briefing. Whoever wrote that knew what they were talking about, understood the architecture of the system, how the smart contracts interacted with the front end that Coburn had created for them, etc. So that was pretty interesting. It's also, so this being the first one that I've ever read, it's interesting to hear you say that it's not typical for the SEC to consider remedial efforts and cooperation from the participant in their penalties then that they award. I have nothing previous to go on, having never looked at this stuff before. But it's a little bit it's interesting to hear that that's not a typical thing that would happen.
Yeah, and to be honest with you, I think it's more the absence of it in previous situations that they were kind of probably bringing this to the forefront, saying that they haven't really had it much. I mean, with Dow, definitely not. Munchie is another example where Munchie was like a legitimate VC-backed company, but at the same time, we're talking about actual tangible acts on behalf of the creators that led to securities violations. So in the Munchie context, you have a situation where they're promising investors a significantly higher return on their investment. And then also on top of that, so for those of you who don't know, Munchie was a blockchain-based restaurant review protocol. And the Munchie business itself was actually going to enter into individual contracts with restaurants. And so they were somewhat dictating the ability of people to review and limit the amount of restaurants they could actually review and post about. And so that really kind of solidified two prongs within the Howey test, which are always the most debated prongs when the SEC does an evaluation over whether something is a security. One is an expectation of profits. And because the Munchie individuals, they were very much soliciting that there was going to be a higher return, that satisfies the expectation of profits. And then their control over the ecosystem in terms of which restaurants could be a part of it, that was the fourth prong, which they were essentially dictating how the profitability of that financial instrument was going to occur. And so with the EtherDelta context, it's clear that Coburn, obviously a very intelligent individual, most likely kind of operated this exchange. And then once the SEC subpoenaed the information from him, he was kind of like, oh, here, I'm just going to put everything on the table, because at the end of the day, I think he understood that the SEC is kind of coming from that protective perspective and not necessarily just trying to go out and find everyone under the sun who's doing this or operating this in the space. It's like they're very much targeting bad actors, and that's indicative of precedent that we've seen in administrative rulings. I mean, there are plenty of instances where people have implemented frauds or scams or something along those lines, where the SEC is very much targeting that aspect of the industry.
Yeah, that makes sense. And I have no inside information here. I don't know Zachary. I've never met him or interacted with him, but he is a younger guy, and he was very active in the community all the way going back to like 2016. He had a couple projects that preceded EtherDelta. You know, he was active on like the Ethereum subreddits and stuff like that. I remember actually very, very clearly when he launched EtherDelta, before it had any traction at all, he would be like popping up in every single subreddit about an ERC20 token, which are the tokens that were tradable on this platform. Would be popping up saying you could also trade these on, you know, on EtherDelta. And my impression is that he is just kind of an enthusiastic young entrepreneurial developer who saw this new technology emerging and had enough of a finance background to kind of hack together this decentralized exchange. And so I think, you know, I don't think he was an intentionally malevolent actor in any way, like trying to scam people. I think he was just kind of an excited, young, maybe somewhat naive guy. And again, that's totally my impression as an outsider, but that would be my best guess. So it's interesting to dive into that briefing a little bit into why the SEC, what made the SEC's case against Coburn so clear, and what kind of some of the language was that they used to talk about why he was guilty. So I'll just read a couple quick things here from this section that's titled "Legal Analysis" from this briefing, and we can throw a link to this in the notes at some point in the chat. So the thing that they seem to indicate is that he caused EtherDelta to violate the exchange, this act, Section 5 of the Exchange Act. And he did that by doing a number of things, including deploying the smart contracts, operating the front end that interacted with the smart contracts. And he also had some limited administrative control over certain aspects within the smart contracts themselves. So he could control, for example, the fees that were awarded to himself for the trades on the network. He could control the rate of those fees. So even though he never held the private keys, because it was a decentralized exchange, he never held the private keys to anyone's assets. He wasn't a custodian of assets, even though he couldn't directly control what was listed on the exchange, what was traded on the exchange, or what wasn't. He did have some limit. He wrote and deployed the contracts. They specifically call that out. He maintained, he had some administrative capabilities in the contracts. He wrote and deployed and publicized. They actually specifically talk about the fact that he publicized the front end of the exchange, so the website that he created that allowed you to interact with those contracts that he had deployed. And it seems like the culmination of those things, the fact that he created it, he deployed it, he publicized it, and he maintained the front end for interacting with it, was more than enough to make it clear that he had stepped over the line in this case. What's not clear is, what subset of those things, if they were different, would have changed the ruling.
Yeah, for sure. And just also to maybe add in another component to it is it's interesting from my perspective, because if you reflect back on the precedents set by the SEC and you go back multiple years before the Dow report, I don't think it would have been the same outcome. And they reference the Dow report specifically, basically saying, we actually put you on notice of this, and why didn't you go out and actually go through the compliance process? So if he had been operating this 2013 to 2015, I highly doubt that they would have had the same outcome, because the Dow report wouldn't have come out yet. There was no kind of clairvoyance in terms of how people are operating these decentralized exchanges and things along those lines. And then the other kind of backdrop to this is a separate governmental agency, probably the second most important in my opinion in terms of the blockchain space, is the Financial Crimes Enforcement Network, and it's a subsidiary of the Department of Treasury. They operate under a different statute called the Bank Secrecy Act. They issued two administrative rulings, one against Ripple Labs, Ripple the company, finding them $700,000 for operating the exchange. Now, to be clear, we're talking about different statutory language because the requirements for compliance under the Bank Secrecy Act are actually different from the SEC's Exchange Act.
So just to make it a little more interesting.
Just to make it a little more complicated. And so from that perspective, they actually had an administrative ruling that directly talked about kind of this gray area that you're highlighting. And it was called the Software and Financial Administrative Ruling of 2015. And basically, they were indicating that under the Bank Secrecy Act, software developers who create decentralized protocols that they don't have control over are actually not culpable, or at least they don't have to be compliant under the Bank Secrecy Act in certain contexts because they don't have control over the software. And so I think that administrative ruling kind of blended into this general notion in the industry that operating a decentralized exchange or decentralized protocol in general will actually not result in any type of compliance. However, up until recently, the Exchange Act under the SEC was not necessarily at the forefront of people's minds in terms of considering their compliance. And this is kind of the tricky tricky aspect of the industry is that navigating these multiple statutes and seeing how they interact with each other, because at the end of the day, we kind of have separate governmental regulatory actions on both sides, and they're interpreting language that is ostensibly very similar, but at the same time has different repercussions, different tests to evaluate. And so in that context, I think that at least if I was a software developer like you've been, and I was creating some project and it was 2014 or something like that, I would have no incentive to register the exchange. I should, pursuant to administrative rulings that we now have. But I think that that kind of was the backdrop to all of this, is that the SEC was saying, hey, we've actually categorized certain tokens as securities. So we've provided some precedent, and namely the Dow report that you were on notice of, and therefore you should have gone through the compliance route once you had realized that we had issued this report.
Absolutely. That makes a lot of sense. So given what we've talked about so far, I want to maybe put you a little bit on the spot, Andrew, if you're okay, and ask you a few questions just to get your opinion. I know you can't, obviously, like we've been talking about, we're all trying to figure this out, including the regulatory bodies themselves. But if Coburn had done certain things differently, if maybe that would have changed the outcome here in any way. So one question that I have, it wasn't really talked about in this briefing, but was the fact that he was profiting from this. Does that weigh in whether or not the SEC is going to come after you or not? So in other words, he added fees into it. He wrote the code such that it paid himself fees, but he didn't have to. This exchange could have operated completely without any fees being paid except the network fees to execute the smart contracts. So if he had done that, if he had deployed this without any fees and just said, hey, folks, I wrote this interesting smart contract that lets you trade tokens, have at it, would that have made him less of a target, less culpable in any way, or is that really not considered at all?
No, that's a great question. It's definitely considered for sure. And I would say that if I just had to give you kind of like a short answer, it would be that I would envision his fee would be less than what it was. And that's kind of the consideration in all of this, is that there's a ruling that was, I guess it's been almost a year now, called, or not a full year, but the Tomahawk ruling. And the Tomahawk was a situation where an individual airdropped all their tokens to build their community. They didn't charge any money, and they gave away all their tokens. Right. And they were still found to violate a portion of the Securities Act because the actual construction of their community, there was some tangible benefit and worth that was associated with that. And so when evaluating whether that token was a security, that kind of went into their overall decision-making process. And so I would say that if he wasn't actually taking that 3% fee that he was taking on each transaction, that he would probably have not had to pay $300,000 with that kind of remedial fee. But at the same time, he would still most likely have been found to be violating the act, because the SEC had already categorized that there were certain tokens that were securities, and that would kind of set that precedent that he was aware of, or should have been aware of. And so in that context, I definitely think that they're factoring in that into the overall equation. And at the same time, that it would be very beneficial for somebody if they weren't charging fees and making a lot of money off of it. But at the same time, you could still face regulatory enforcement action, even if you're not actually receiving a $sign upon each transaction or something like that.
Okay, cool. Yeah, because it wasn't really discussed in that briefing. Curious. It sounds like what you're saying is it wouldn't stop you from being in breach of the law, but it might affect the way that you were ruled against, to what extent you were.
And if you look at the language that they use, then they're citing what an actual exchange is under the Exchange Act of 1934, that it's not necessarily highlighting what a lot of people in this space are considering to be the end-all be-all SEC test, which is the Howey test. It's very much looking into how the exchange itself operates and what it allowed users to do, rather than specifically determining each token. Yeah,
that's a great point, and that actually segues into another kind of one of these questions that I have for you. So in that briefing, if that's the right term to use, they talked a lot about the front end and the fact that he owned the website for EtherDelta that allowed you to interact with the smart contracts, and that he created the interface. And they also talked specifically about, as you were just mentioning, it's very clear that that this was an exchange, right? It showed an order book, it matched pairs of orders, it showed, you know, moving price averages, and they call out these aspects of the interface, and they actually include a screenshot of it in the brief that say like, look, this is an exchange. You can tell that it's an exchange. So what is interesting there is that, so his interface that he created didn't have any privilege because of the way these decentralized systems over the exchange, over an interface that anyone else could have made for the system. You know, again, once you deploy those smart contracts, except for specific, excuse me, except for any specific capabilities that you give yourself in the code, that code is just going to run. And so anybody could have, I don't know if anyone did, but anyone could have written a front end that they thought was better than his to interact with his smart contracts. So my question is, is that something that people should be worried about? Like, say you really like the Augur project, and you're not sure Augur is a prediction market. You're not sure if that's a compliant project or not, but you think that the app that Augur has created, the front end that they distribute, is kind of crap, and you can do better. You're a designer, and you create a better interface and make it easier for people to create prediction markets on Augur. Do you have to worry that by creating an interface that interacts with decentralized smart contracts that someone else wrote and deployed, you might be in some way, you know, guilty or non-compliant? What are your thoughts on that?
Yeah, absolutely. From that perspective, compliance should be at the forefront of your mind, especially if you're developing the UI, the user interface, because at the end of the day, that's really what it is that they're highlighting. And kind of referencing the administrative ruling from FinCEN that I talked about earlier, that was really talking about, oh, I can create this open source decentralized protocol, release it to anybody, and I'm not necessarily culpable. But once I start actually building on it, advertising, the general solicitation portion of the Securities Act is extremely important for a lot of businesses that are operating the space. They have to be very careful about the language that they're using, from everything from their private placement memorandum, if they're actually offering a token, or even the terms of service on their website. And so when developing the actual software itself, that should be the consideration. Am I going to be building this platform to be able to allow users to access it? Am I building that actual user interface? Am I soliciting that user interface, whether it's on a subreddit or an actual like legit publication? And so those are all kind of considerations, and something that someone who's developing that type of product should definitely consider. And interestingly enough, if you are actually have nothing to do with the base protocol, that doesn't necessarily matter, because again, just kind of referencing the smell test, is that that's kind of what is really prevalent in the EtherDelta opinion. And also, I mean, that kind of like leads us to the conclusion that it was very straightforward. It's like, this is clearly operating very, very similar to something that would look like an exchange. And therefore that is eventually the conclusion that they came when interpreting the statutory language. So if I'm a software developer, and again, I'm advising software developers constantly, I'm really talking to them, and especially in the exchange context, and not even fully decentralized exchanges. I mean, this runs the gamut. We go all the way to full on centralized exchanges, which can be typically easier because they most likely will always have compliance. But in the decentralized context, you got to think about kind of who it is that what you're creating is it providing to. Like if I'm providing this user interface for a user to go on and enter into a trade, I'm most likely operating this.
See, that's fascinating. And that is something that I think, I know certainly it's news to me. I can't speak for other technologists, but from a developer perspective, that feels really weird, right? Like this idea that, because we're used to thinking of things in this kind of client-server architecture. And to me, it feels like, you know, creating like a Twitter client to interact with Twitter, like a third-party Twitter client, you know, like how could I get in trouble for the content or the activity on Twitter if all I did was just create a third-party client for accessing Twitter? But what I'm hearing you say is that actually people creating interfaces for these decentralized protocols, even if the protocols are created and deployed by someone else, if you're enabling end users and you're, you know, publishing something and promoting something to users that is going to allow them to interact and do something that, you know, the SEC considers problematic, that you, even as not the creator and not the maintainer of the protocol, you might be out of compliance. And so that, I think I could say, speak for myself, that's news to me, and that's interesting to hear. I think a lot of developers would be surprised to hear that based on the way that we think about how technology works.
Right, yeah, and it's funny because that's been kind of the underlying thematic point throughout these administrative rulings dating back multiple years now to the Dow report, and it's very much that they have actually been quite clear now through their opinions that they factor in the underlying software, but it's not a large component to their evaluation. And they're really kind of taking these traditional tests that have been in place for many, many years and evaluating the technology from that perspective. And so in that context, it's interesting because going back to that scenario where I develop a decentralized protocol, I open source, or it's open source to everybody. Someone comes in, builds a UI, and then operates an exchange. That person is liable in terms of compliance. I, on the other hand, is still up for debate. It's very much kind of a gray area because like how do I have control over somebody who's developing on the platform? So in this context, if Coburn had simply just released the EtherDelta protocol and not build out a UI and not talk about it or anything like that, there would most likely not have been the same result.
See, that's fascinating too, because I was going to ask you that exact flip question, which was that, like say I developed the protocol for a decentralized exchange and I deployed the smart contracts, but I didn't create or promote any interface for them. It sounds like you, in that case, a person who decided to create an interface might actually be more culpable than myself as the creator of the smart contracts who deployed them. Now, what about there's kind of a gray area where maybe I create the smart contracts and I don't create an interface for, quote unquote, normal users, and I don't promote it to normal users, but maybe I go on a developer subreddit and I say, hey, check out this cool, protocol for decentralized exchange that I just deployed to Ethereum. Here's the address for the contracts. Here's the functions that you can call. It'd be neat if someone made an interface. Like that seems like another gray area. I don't know what I don't know if there's a good answer as to what would happen in the case like that.
Yeah, for sure. And to be honest with you, I think this is where we kind of have shortcomings in the limited amount of precedent that we have from both the SEC and FinCEN. And in that example, just to hypothesize, it would seemingly be that if there's some type of promotional link, that you just need to be very, very careful and think about what your compliance is. And at the end of the day, the SEC is coming at it from the approach of they're evaluating it on a case-by-case basis. So just to give a little bit of insight, the way these things work is that the SEC will subpoena information from an entity or business, and the business submits to them their information, everything from promotional documentation to maybe the actual language for the smart contracts. And then they go through that and parse through it and determine and then evaluate and base their overall conclusion on that information. And so we have a couple different instances where they now have subpoenaed information from a lot of different companies, and we're just slowly seeing them roll out. And that's going to continue on for at least a couple more years for sure, until we have things like the judiciary stepping in or the legislature stepping in and actually providing more clarity in terms of definitions surrounding some of these external terms, such as traditional decentralized exchanges and things like that. And we're seeing a kind of a demand from legislators, which has actually been pretty nice. I know it was a couple months back, but the Congress, there was 6 or 7 congressional representatives that actually sent a letter to the SEC looking for clarity because they were working on defining some of these terms that have been operating in the blockchain space, but don't actually have any statutory definition. Because if they can define those terms, then they can actually have some better insight and provide better clarity for those operating in the space. Because then we can take the legal or the administrative rulings from the SEC. We can take some of the legal opinions, which are even more underdeveloped, in my opinion, compared to the administrative rulings of the SEC. And then we can combine all of that with actual congressional approved definitions and then be able to kind of pull all of those things together to have a much clearer path for regulatory compliance.
Wow. All right, cool. Wow. So I could talk about this stuff forever. I could pick your brain on this forever because, it's fascinating to me. And it's also, directly impacts me as a developer who's thinking about building in this space. I have one more kind of hypothetical that I want to ask you about. And then we can maybe start to wrap up just because I want to respect people's time and get done by noon so folks can get to lunch and that sort of thing here on the East Coast, at least. The one hypothetical I want to ask you about that we haven't touched on yet is, what if I just create the code for this and I don't actually deploy it or host it in any way myself? So this could be the code for, say, the smart contracts enabling a decentralized exchange. This could be the code for the front end like a website or another form of app that interacts with the smart contracts. I write that code and I open source it. I publish it under an MIT license on GitHub. Maybe I post a link to that code in in a subreddit or on Hacker News or something like that. Maybe it's just a side project or something that I'm hacking on. But is there any culpability if I've just created the code? I haven't even deployed it. I've just created and open sourced the code that can run this. What is your sense there of how that might play out?
Yeah, for sure. I would think that it would be on the lower end of the spectrum in terms of your compliance. And realistically, that kind of goes back to this overall scale in terms of the evaluation from the SEC's perspective, because in that context, if you're simply releasing the underlying protocol that you've developed and there's actually no direct functionality or development that you've contributed beyond that, your culpability would most likely be lower. Now, again, there are plenty of scenarios where that wouldn't be the case, and it all kind of depends on what the individual did in terms of actually releasing it on GitHub, the language that they stated when they were just talking about it, and all of that stuff kind of comes into the general evaluation process for the SEC. In that context, if it were to go out and then be developed into something more substantial, the parties that did that development, obviously, they should have compliance much more at the forefront of their mind rather than the initial developer. But at the same time, even then, it's most likely beneficial to just read some of the administrative opinions, maybe talk to an attorney. I know that's a little bit self-promoting, so I don't necessarily want to go down that path, but it's kind of one of those things where there's certain administrative rulings that have come out by the SEC and they haven't been widely publicized that can lend a little bit of insight into those types of situations. But at the same time, there is kind of this cliff and this drop off that we're still waiting for clarity. We're still waiting for more examples to come out to show, okay, how far down the rabbit hole am I in terms of software development where my culpability is actually no longer there. And that's soon to be determined for sure, but has yet to be determined.
Yeah, so it sounds like there's, even around that case, it sounds like you'd likely be less culpable, but there's still ambiguity and gray areas. And I think my fear in all of this is that while we certainly, I think a lot of people on the technology side look at regulation as a dirty word, a bad word. I don't have that perspective. I think that there is a clear role that the SEC has played historically to protect to protect people from 2017, I think, has taught us that there are lots of scammers out there who will use every tactic in the book to take money from people if they're given the opportunity, right? And so I think there's clearly a role for the SEC to play. My concern is that we're going through this transition period right now where there's so much ambiguity, as we've just been discussing, and I'm a little worried that if we don't get clarity on some of this stuff, it's really going to create a chilling effect on the innovation, the upside, right? So the downside is the scams and all the bad things that can happen. But I think most of us that are working in this space are in it because we see this tremendous potential and upside for this technology as well. And my fear is that if there's this kind of this cloud hanging over of, I might be in violation of some regulation I didn't even know about or understand, just trying to hack together a side project, that's really going to create a chilling effect. And I could just speak for myself as an engineer. Some of these previous cases, and I think the EtherDelta case in particular, it does worry me a little bit, and it makes me a little bit more cautious. Maybe that's a good thing that I'm more cautious, but I could see myself, a younger version of myself at least, being the guy who created something like EtherDelta, right? Who just like found the new technology and had just enough knowledge to hack it together and like threw it together and put it up there. And the next thing you know, you're getting nasty grams from the SEC, and that's a little bit scary. So I think that's my concern. And in that context, my question to you, Andrew, would be, what can those of us do who are thinking about starting projects, companies, maybe just, like I said, hacking around on something on the side that's purely a side project? What can we do to protect ourselves, to comply, to do everything, do everything that we can to make sure we're we're protecting ourselves and following these laws and regulations that exist for very good reason?
Yeah, for sure. And as a side caveat, I definitely share in that sentiment. I'm equally as concerned about the stifling that could occur. And really, it's interesting because while I don't necessarily want this to be the full kind of fallback, but I do think that there will be more judicial opinions that will come out of these instances where someone has appealed the administrative ruling against them and they're actually fighting it. unlike in the Coburn context, and then they take it to the courts, and then they actually have a judge evaluate it. And I know that I referenced that Blockfest one, which I think is pretty important because it's at the federal level. So it's a federal court that actually administered that ruling. And so there is a potential for some precedent, not much in that context, but it also allows for the opportunity for the appeal process, potentially go up to the circuit courts. And so that kind of poses a potential solution, but at the same time, the judicial courts operate extremely slowly. And so from that perspective, it would really not be great to only rely on that. And also with the side caveat again, that it's nice that the SEC has kind of been forthcoming about how they're trying to tackle this exact issue. And their recent release of FinHub, which is a portal that you can actually interact with them via an attorney or as a client, and that's really beneficial. So, which actually kind of bleeds into the answer into what you can do for compliance. And I think that, interestingly enough, if there's concern around whether the project or individual operating the software, developing the software wants or needs to have some type of clarity, the governmental agencies are pretty open. And that's kind of one of the benefits of having such a substantial administrative branch in our country, is that they are paid by our taxes, and therefore they are somewhat there to serve us as individuals and businesses and clients. And so really reaching out to them, contacting them through an attorney. I've been speaking to them pretty frequently and talking with them from their perspective. And it's interesting because I've definitely deduced that in certain scenarios, they were very much like, if this project has simply just come to us and asked and really just given us this question, and maybe not necessarily like extravagant hypotheticals or anything along those lines, but really was just clear in what their question was and whether they needed to be compliant, we could have given them a straightforward answer and not had to deal with all this administrative bureaucracy and then leading them to potentially getting fined or even maybe their project failing, especially in the Dow and Munchie context. And so from that perspective, and that also with the side note that compliance is not, it's not this crazy uphill battle that I think people envision it to be. Now, of course, Coinbase and major exchanges that are fully centralized need money transmitter licensing in every state. That can be a pretty substantial regulatory ask. But at the same time, there's a lot of other projects and so much in between in terms of the compliance with the SEC, FinCEN, where a lot of times it can just simply be annual reporting. Or you're filing a notice with the SEC to put them on kind of notice that you're potentially issuing a restricted security or something like that. And so at the end of the day, I think that the compliance, while it can seem a very, very uncertain area, there is some sound precedent and some pathways that we can navigate. And at the end of the day, really finding kind of that sweet spot and determining what the project's actually doing, what it's trying to target, what its potential compliance is feasible. It's not non-existent, and it's not completely impossible.
Awesome. Sounds good. And now, Andrew, you may be a little hesitant to promote yourself, but I don't have to be shy about that. So I can just say to anybody out there who is pursuing a project or something like that and is looking for legal advice, Andrew is top-notch person to talk to. Andrew, I know you were writing about and thinking about the regulation of Bitcoin and blockchain more generally long before it was in the news, getting all the hype that it was 4+ years ago. Andrew was already into this stuff and into this space. So he knows his stuff. He's in it for the right reasons. And so I've already learned a ton from him since we met last year about the regulation in the space. And I can highly suggest anybody who is looking for specific legal advice about your project to reach out to Andrew. And so with that, Andrew, I'll also just thank you for taking the time to join me today and talk about this. I actually learned several things during this conversation, and it was super helpful. I hope it was also helpful to folks out there.
Absolutely. Yeah, no problem. My pleasure.
So before we wrap up, I will, it is about 5 minutes to 12. So if there is anybody out there who is listening right now, a number of people who are on the live stream, if anybody has a question, I don't see anything that's been asked so far. But if anybody does have a question, now would be the time to drop it into the chat or into the ask a question box, and maybe Andrew can take a crack at it. While let people have a minute to think about that, while they're doing that, I'm going to just bring up real quickly again the screen and just suggest that everyone follow Andrew on Twitter. Here's his email. If you, oops. That is the wrong email. That is not your email, so I apologize for that. Andrew, do you want to just share your email? That's from an old slide that I copy pasted from. So now you can share your email in the chat. I believe is it Andrew at bullblockchainlaw.com. Is that right?
Yeah, exactly. Yeah,
great.
Sure.
So Andrew at bullblockchainlaw.com if you want to get in touch with Andrew via email. And of course, you can just check out his website and reach him there. And then I'll just, again, real quickly, direct you toward my own Twitter, my own email. Please, by all means, reach out to me. I do always love to hear from folks. And buildblockchain.tech initiative, if you're interested in more technical and developer and entrepreneurial centric resources like this. So let's see. While we were chatting there, did anyone feel brave enough to ask a question?
So I don't necessarily see one, but I can address a common one that I typically get in these scenarios. Is that we've been talking a lot about culpability or surrounding projects and businesses and that type of context. Oh, okay. Well, we do have a question from John.
Great.
Yeah. So the question is, doesn't Bernstein versus US make the case very clear for undeployed SC code or unhosted front-end code? So to a certain extent, well, maybe Ben, do you want to do a little bit of clarification about undeployed SC code or unhosted?
So undeployed SC code, I assume John is talking about smart contract code that you've written and hosted, published the code on GitHub, and unhosted front-end code would be like a similar thing. But the smart contract code would be you haven't deployed it to the Ethereum blockchain. You haven't put it on the blockchain so that it can execute there. But you've written it and put it up somewhere so that other people could download it and could subsequently deploy it to the blockchain. Unhosted front-end code would be similar. It would be like a website code, the HTML or JavaScript, or maybe an iOS app or something similar, where you've created that code and you've put it up on GitHub somewhere, and anyone could take that code and subsequently, buy a domain name and an Amazon Web Services server and host it themselves and make it available to other people. And I think the case I know a little bit, or host locally. Great point, John. Right? You could deploy the smart contracts yourself and then host the front end locally yourself and execute against the smart contracts. That's a very good point. I think that if I have the case that John's referencing correct, John, correct me if I'm wrong. This is a case that specifically, I think, treats code as speech, so that code is speech and therefore is protected generally by free speech. And I do think that there's been a little bit of discussion about this in the context of these decentralized systems as to whether that might be up for grabs if you're creating smart contract code that could cause these problems. I don't know, Andrew, do you have any opinions there?
Yeah, absolutely. And I mean, this is a hotly contested topic for sure, is trying to figure out what the compliance side of things, its impact on, in this case, constitutional rights, because that's really what they're referencing at the end of the day. And maybe just to separate a couple different things in regards to this case in particular is that with code, even if at the end of the day that we're assigning some type of fundamental right that we actually have in terms of providing this as speech under the First Amendment, that there's caveats to all the rights under the First Amendment. And so the parameters that have been developed by governmental agencies over years and years and years, regardless of whether it's burning a flag or holding up a sign that says bong hits for Jesus, the overall notion is that you are trying to figure out, okay, where are the outside parameters for that? So even though Bernstein certainly does make sure that these types of unhosted or locally hosted code that's actually existing can be kind of fall under that category, the compliance side of this in terms of the statutory interpretation of the Securities Act and then also the Bank Secrecy Act, those things are somewhat separate. And now, of course, you can rely on constitutional rights as a defense, but in the administrative context, it's somewhat of a different, there's a thing called standing, and you need standing in order to be able to bring a certain argument, or even to be able to bring an argument in that context. And so really when thinking about how you're going to bridge the gap between whether your code is protected under the First Amendment, that can be extremely important in the context of some type of judiciary decision. But at the same time, an administrative ruling is really looking at the statutory language within a specific statute, namely the Securities Act and the Exchange Act. And so in those aspects, it's somewhat a bit different. And therefore, even if something is protected under the First Amendment to a certain extent, your culpability in terms of actually soliciting that software or entering into transactions or facilitating transactions or even developing a decentralized platform and then developing a UI and promoting it, you might still be culpable in that context, even if there is this fundamental kind of First Amendment protection.
Yeah, so I think what you're saying is that because this new, and because there are, at the end of the day, there are some limits on even the First Amendment rights, even on free speech, right? Like there are some limits on that. That what we could see is, you can't 100% rely on that. In other words, if you create some code that enables something that's clearly illegal, and you publish that code, and you go around talking about how you've published that code and promoting it, but you don't deploy it yourself, you might still find yourself in court. And because this is also new, that's going to be it could end up being a long, drawn out litigation to figure that out, because it hasn't been, it's not an open and shut case, is what I'm hearing you say.
Yeah, to a certain extent. And I mean, John's question, it hits the nail right on the head. I mean, it's subject for debate of how the constitutional fundamental rights that were assigned under the First Amendment really bleed into the administrative component of the structure of our government. And there's interaction there, certainly, in plenty of contexts. For example, you're actually right to have the administrative ruling at all is a constitutional right and fundamental right for due process. So that's kind of an example where you're allowed to be there in the first place, but at the same time, there are caveats and limitations to how much of that argument you can bring to the table in an administrative ruling context. Now, again, if you appeal that and you go into the court system, then it's much more prevalent and much more of you have a leg to stand on in that context.
Fascinating. Well, John, that was a really, really good question. I'm glad you brought that up, because that had actually been in the back of my mind, this idea as code as speech. And so I'm glad that we got a chance to talk about it. We're up over an hour now. It's past noon here on the East Coast in the United States. So I think this is a good place to wrap it up. But Andrew, I just want to reiterate again, I really appreciate you taking the time this morning, and I appreciate all of you who joined us on the live stream. This has been a super edifying conversation for me, and I have a feeling I'm going to be picking your brain on more of these things over coffee sometime, Andrew. So thank you for taking this time to do this in public.
Absolutely. It was my pleasure.
All right, everybody. Enjoy the rest of your day. Have a great weekend, and talk to you next time.
All right. Thanks again, Ben.
Bye.